Jefferson County Court at law number 2 is now in session. Court has 2 dockets, motion to revoke probation docket and the announcement docket. First case we're gonna call is on our announcement docket on page 2. Is that Michael Raven Peterson? Okay, you may come forward. Hold on it, okay. All right. Just have a seat. Let's get some pro se. Let's get, well, I could go on Zoom on this one. Oh. No, I was looking at on the announcement docket, the first case. Next case is cause number 329-826. Case is style of state of Texas versus Anil Shandali. Mr. Shandali is appearing via Zoom. Mr. Shandali,
yes, Your Honor.
How are you doing?
I'm doing great. How about yourself?
I'm doing fine. Hold on a minute. Okay, Mr. Shandali, how are you
Yes,
doing?
Your Honor. I'm doing good.
That's good, Mr. Shandali. The state is represented in this case by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm doing well, Your Honor.
Okay. Now, Mr. Shandali, your case was reset back in November the 5th of 2021 for you to hire an attorney?
Is there any possibility I can go a little bit further than that?
We're gonna give you 30 days, that's it. I mean, it's this thing has been going on too long.
Okay, November what, sir?
Give him 30 days in October.
It's October 20th.
Okay, this case is reset to October 28th. That's your last reset.
Okay, thank you, Your Honor.
Okay, so this case is reset to October 28th of 2022. On that date, you need to be here in person.
Okay, yes, Your Honor.
All right. So,
right.
Okay, this case is reset for you to hire November 28th, 2022. This will conclude your case. You're free to go and you have a blessed day.
Thank you so much.
All right, thank you. Next case is cause number 331-712. The case is filed the state of Texas versus James William Hunter. Mr. Hunter is appearing via Zoom. Mr. Hunter, you take your mic off of mute. Oh, he just not popped in. Next case is cause number 331-712, case to style the state of Texas versus James William Hunter. Mr. Hunter, how are you doing?
I'm doing good. How are you doing today?
Oh, I'm doing fine. Now, Mr. Hunter, your case was reset to give you an opportunity to hire an attorney. Is that correct?
Yes, sir, it was.
Have you hired your attorney?
So I ran across a couple issues. I mean, right now, they had ended up letting me from working offshore and put me in a plant out here in somewhere down here in Texas. So I'm in Freeport. They sent me out here to LNG. So, I mean, my time was cut down. I just got back to work. So, I mean, I wasn't able to hire one, but at this point, I'm just willing to plead guilty to it. So, I mean, prosecutor tell me what they want from me. I'll tell them if I can give it to them.
I think, Mr. Hunter, the last time you came in, you were given judge's explanation of rights to defendants without an attorney, and in that document, it stated that you had three options. You can hire an attorney. If you could not afford an attorney, you can request an attorney be appointed to represent you, or you could represent yourself. Now, if you represent yourself, you cannot speak to the prosecutor unless you sign a written waiver of your right to be represented by an attorney. And so basically, that has not been done. So you cannot at this point talk to a prosecutor. So,
Yes, so how can I go about doing that?
Well, you need to come here. You need to be in court in person to fill out the proper documentation. You have to fill out a new judge's explanation of rights to defendants without an attorney. And if it's your desire to represent yourself, you will have to read the document and make the choice and stating that you want to waive your right to an attorney, which means give up your right to an attorney and represent yourself. And you will have to read and sign a written waiver of counsel for purposes of entering a guilty plea or proceeding to trial. So those things has to be done before you can talk to a prosecutor. So what we can do is schedule you a time to come into court, so you could do that in person.
Okay. What if I just want to plead guilty to it? What are my consequences?
I can't give you any legal advice. If you want any legal advice, you need to talk to an attorney.
Okay. All right. When could I come in?
Well, let's see. What about November 4th?
Sorry, said I. Well, yeah, because we should be slowed down by then. So yes, sir, that's fine.
Okay, so this case, let me see, Mr. Hunter. Okay, will be reset to November 4th of 2022. Stay in contact with your bondsman. Now you need to be here in person. Court starts at 9 a.m. Every morning. So this is November 4th of 2022 at 9 a.m. in County Court at Law Number 2 of Jefferson County, Texas. This will conclude your case. You're free to go, and you have a blessed day.
All right, yes, sir. You too.
All right, you're welcome. This is cause number 330-462, case to style of state of Texas versus Eugene Booth III. Mr. Booth, is that your full name?
Yes, sir.
How you doing, Mr. Booth? That's good. Now, Mr. Booth, you signed a written waiver of your right to have an attorney, and you're designed to represent yourself. Is that correct?
Mhm.
Okay, just have a seat, and then we'll have one of the prosecutors will talk to you.
All right.
Just have a seat under the gallery. Next case is cause number 311-988. The case is style of state of Texas versus Markeisha Bernard.
Yes, sir.
Ms. Bernard, your full name Markeisha Bernard.
Yes, sir.
Okay, how you doing, Ms. Bernard?
I'm fine with you.
That's good. Ms. Bernard, I have before me a motion to revoke your unadjudicated probation that was filed by the Jefferson County District Attorney's Office on April 25th of 2019. In this motion, it alleges that you, Markeisha Bernard, in the style and number cause, that means in the case that's the state of Texas versus Markeisha Bernard, and the number is 311-988, that you were tried in County Court at Law Number 2 of Jefferson County, Texas, on March 20th of 2018 for the Class B misdemeanor offense of theft. The court found that the evidence was sufficient beyond a reasonable doubt to find you guilty. However, the court deferred of finding you guilty and placed you on unadjudicated probation for a period of 1 year. In this motion, there are three allegations. Now, the first allegation, Ms. Bernard, alleges that you failed to report to the Jefferson County Probation Office as ordered by the court for the months of February, March of 2019, in violation of your condition number 4 of your probation order. Allegation number 2 alleged that you, Markeisha Bernard, failed to pay court-assessed fees as ordered by the court, and as of March 27th, 2019, you were $198 in arrears in violation of condition 8 of your probation order. And allegation number 3 alleged that you failed to perform community service hours required as ordered by the court in violation of condition 14 of your probation order. Now, if the court finds that any one of these conditions, or that you violated any one of these conditions of your probation, or any one of these allegations, your probation may be revoked. And if your probation is revoked, you can receive up to 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Ms. Bernard, as a defendant in the criminal case, you have rights. One of the rights that you have in your motion to revoke probation case is you have a right to have an attorney. And in regards to your right to having an attorney, you have 3 options. Number 1, you may hire an attorney. Do you understand that option?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option?
Yes, sir.
And number three, you may represent yourself. Do you understand that option?
Yes, sir.
Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. That is, if you desire to represent yourself. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, this document that I have, you need to be here in person to read this document and sign and make the choice that you would like to make. Now, in this document, it has defendant's choice. If you want to reset your case to hire your own attorney, then you'll put your initials on the first line to the left. If you've already hired an attorney to represent you in this case, you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is you want to reset this case, well, if your choice is you want to apply for a court-appointed attorney, then you'll put your initials on the third line to the left. If you've already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. And if you want to waive your right to an attorney and to represent yourself, then you'll put your initials on the fifth line. And then once you finish initially one of the 5 lines, then you will sign the document on the line that says defendant, and you will date it on the date that you're in court. So, Ms. Bernard, this case is going to be reset to give you an opportunity to be here in person, to go over the documents and to make your choice. So at this, could you give us a reset date? Now, this case, Ms. Bernard, is going to be reset to November 4th of 2022. You need to be here in person at 9 a.m. so that you can sign the appropriate document.
Okay.
Okay, so that's November 4th of 2022 at 9 a.m. So at this time, Ms. Bernard, you're free to go, and you have a blessed day.
You as well.
All right, you're welcome. Okay, now, Mr. Kimler, your client has not arrived. Heavenly Andrus.
She had messaged me that she was on her way, Your Honor. She knows the court date, so I anticipate she will be arriving shortly. So
Okay. When she arrives, we'll call the case.
yes, Your Honor.
Okay. Okay. The court is back in session in the motion to revoke probation docket. We have two cases. Both cases are styled the state of Texas versus Gustavo Gomez Vasquez. Mr. Vasquez, is that your full name?
Yes, sir.
And the first case is cause number 322-623. Second case is cause number 324-253. Now, Mr. Vasquez, in each case, I have a motion to revoke your probation. And cause number 322-623, the motion to revoke probation was by the Jefferson County District Attorney's Office on June 20th of 2022. And this motion alleges that you, Gustavo Gomez Vasquez, was tried on July 16th of 2021 for the offense, for the Class B misdemeanor offense of theft. And the court found you guilty, and you was assessed punishment at a term of 90 days confinement in the Jefferson County Jail and a fine, and no fine. The fine was waived. Your confinement was probated for a period of 1 year. In this motion, Mr. Vasquez, there are 4 allegations. The first allegation alleges that you, Gustavo Gomez Vasquez, failed to report to the Jefferson County Probation Office as ordered by the court for the months of April, May, June of 2022 as directed in violation of condition 4 of your probation order. Allegation 2 alleges that you, Gustavo Gomez Vasquez, failed to pay court assessed fees as ordered by the court, and as of June 13th of 2022, you were $273 in arrears in violation of condition 8 of the probation order. And well, allegation number 3 alleges that you, Gustavo Gomez Vasquez, failed to perform community service hours required as ordered by the court in violation of condition 14 of your probation order. And allegation number 4 alleges that you, Gustavo Gomez Vasquez, has failed to pay for, enroll, participate, and successfully complete the theft education program as ordered by the court in violation of condition 19 of the defendant's probation order. Now, if the court finds that one of these allegations is true, your probation can be revoked. And if your probation is revoked, Mr. Vasquez, you can receive up to 90 days confinement in the Jefferson County Jail. Do you understand that? Now, the next case, cause number 324-253, I have a motion to revoke probation in that case as well. That was filed by the Jefferson County District Attorney's Office on June 20th of 2022. And this motion alleges that you, Gustavo Gomez Vasquez, was tried on July 16th of 2021 for the offense of animal cruelty. And the court, you was found guilty and assessed punishment at 270 days confinement in the Jefferson County Jail and a fine of $2,000. And in accordance with Article 42.12 of the Texas Code of Criminal Procedure, your confinement was probated for a period of 2 years. And there are 3 allegations in this motion. The first allegation alleges that you, Gustavo Gomez Vasquez, failed to report to the Jefferson County Probation Office as ordered by the court for the months of April, May, June of 2022 in violation of condition 4 of your probation order. Allegation number 2 alleges that you, Gustavo Gomez Vasquez, failed to pay court assessed fees as ordered by the court, and as of June 13 of 2022, you were $277 in arrears in violation of condition 8 of your probation order. And allegation number 3 alleges that you, Gustavo Gomez Vasquez, failed to perform the community service hours required as ordered by the court in violation of condition 14 of your probation order. Now, Mr. Vasquez, if the court finds that one of these allegations is true, your probation can be revoked and you can be placed in the Jefferson County Jail, or you can receive punishment for this offense in the Jefferson County Jail for a term up to 270 days. Mr. Vasquez, do you understand that?
Yes, sir.
Now, Mr. Vasquez, you are, and I'm looking at my notes, you're not a U.S. citizen, is that correct?
Yes, sir.
Now, what country are you from?
Mexico.
Okay, now, I have a document here, and it states for all foreign nationals except those from mandatory notification countries. Mexico is not a mandatory notification country. And it reads, as a non-U.S. citizen who is being arrested or detained, you may request that we notify your country's consular officers here in the United States of your situation. You may also communicate with your consular officers. A consular officer may be able to help you obtain legal representation and may contact your family and visit you in detention, among other things. If you want us to notify your consular's officers, you may request this notification now or at any time in the future. Do you want us to notify your consular's officers at this time?
No, sir.
Okay, so what you're gonna have to do, there's a document here on this document. If your answer is no, you will circle no. And you print your name where it says print and put your signature where it says signature. We're gonna have, maybe somebody would have to witness this form. Now, do you need some time to read that document?
No, sir, that's fine. No.
You understand?
Sir.
Okay. Okay. Does he have a judge's explanations? Okay, now, Mr. Vasquez, the document that you have before you is titled Judge's Explanation of Rights of Defendants Without an Attorney. As a defendant, you have a right to have an attorney. And regarding your right to have an attorney, you have 3 options. Number 1, you may hire an attorney. Do you understand that option? Number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option? If you speak up, okay. Number 3, you may represent yourself. Do you understand that option?
Yes, sir.
Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in the worst outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Do you understand that? Now, at the bottom of that document, it says defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. If your choice, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney, which means to give up my right to an attorney and represent myself, then you will place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign at the bottom, your signature at the bottom of that document on the line that's titled defendant, and you will place today's date on the line that's titled date, and today's date is September 23rd of 2022. Do you understand that?
Yes, sir.
Okay, you can go ahead on and make your choice. Okay. Mr. Porter, could you give me that document? Thank you. Okay, you like to, now, let me do this here. You like to apply for a court-appointed attorney? We need to give him a financial affidavit and affidavit of indigence. You're gonna have a seat at that table right there, and you can fill out that application. If you need any assistance to fill out the application, we have someone in our court who can assist you with that, okay?
Thank you.
You're welcome. Hey. Okay, the next case, we have 2 cases, cause number 331-804 and cause number 333-086. Both cases are styled the state of Texas versus Jasmine Dion James. We have Ms. James who is appearing via Zoom. Ms. James, you could take your mic off of mute.
Yes, sir.
How you doing, Ms. James?
I'm fine, and you?
I'm doing fine. Thanks for asking. Ms. James, you're represented in your case by your attorney, Mr. Dustin Galmore, who is also appearing via Zoom. Mr. Galmore, how are you doing?
I'm good, Judge. Good morning.
Good morning. Mr. Galmore, what is your announcement in Ms. James' cases?
Judge, one of these cases is new, so we just requested discovery yesterday. We're going to need another announcement date.
Okay, I'm looking at the court docket. It seems like Ms. James has 2 cases in drug court, which is set, both of those cases are set for October 3rd of 2022. Would you like to keep cases together with the felony cases?
That would be fine.
Okay. So, Ms. James, your cases are going to be set with your felony cases. Your felony cases are set on October 3rd of 2022. Your attorney and your bondsman will be given notice of your reset date. On that date, October 3rd, 2022, you need to come here, check in, and then go to the drug court and check in over there. Once you finish in drug court, you'll come back over here to inform this court the status of that case so we can keep these cases together. Do you understand?
Yes, sir.
Okay, so Ms. James, stay in contact with your bondsman and your attorney. They will be given notice of your reset. This will conclude your cases. You're free to go, and you have a blessed day.
Okay, thank you.
Should
Yeah,
have
Mr.
one more,
Gilmore.
Judge. Yes, I should have one more.
All right, and that's Econ, is that correct?
That is correct.
Is Econ, is Econ, hold on, the bailiff is gonna see if Econ is present.
Or there's an iPhone on the Zoom.
I think that was somebody else. That might have been Banks. Yeah, they're not here in person. You might wanna, we'll give you the opportunity to contact
Well,
Econ.
Judge, just so you know, this was a motion to withdraw that I'd filed, and we had a hearing on it 6 weeks to 8 weeks ago. And I believe the court took it under advisement. And then I just found out this week that it was set for today. I don't know why it was necessarily set for today. I was just hoping for the court to grant the withdrawal.
Okay, I'll have to take a look at that. We had Miss Econ. I don't know why. Yeah, she was supposed to make an appearance. Just, I'll tell you what. The court has a couple other matters that it has to take care of, and we'll come back to that one.
Okay, Judge, I'm going to step into court in Orange County, and then I'll get back on when I'm done.
That's fine.
Thank you.
All right, you're welcome. Court is back in session. In cause number 331-936. Case is style of State of Texas versus Michael Raven Peterson. Is that your full name? How are you doing, Ms. Peterson?
I'm doing okay.
That's good. Ms. Peterson, you're here represented by your attorney, Attorney Marva Provo. Attorney Provo, how are you doing?
I'm doing fine.
That's good. And the state is represented in this case by Attorney Lamar Johnson. Attorney Johnson, how are you doing again?
I'm doing well, John. Thank you.
Now, Ms. Provo, what is your announcement? And Ms.
Your Honor, we're going to ask that this case be reset on the announcement. Stop for one more time. We just got our offer.
Okay,
Give us some time to explore.
okay, state, you have any objections?
No objection, Your Honor.
Okay, we're gonna reset it for an announcement. You gotta give us a reset date. Okay, this case will be reset to November 4th of 2022. Once you get your reset, Ms. Peterson, from your attorney, you'll be free to go and you have a blessed day. And Ms. Provo, once you sign for your reset, you'll be free to go as well and you have a blessed day. Yes, you may be excused. Next case is cause number 331054, case of style of state of Texas versus Cameron D. Brown. Cameron Brown is appearing via Zoom. Mr. Brown, how are you doing? Oh, Mr. Brown, you could take your mic off of mute. Uh-oh. Oh, there he is.
Hello?
Yeah, Mr. Brown, how are you doing?
All right, how you doing, sir?
I'm doing fine. Thanks for asking. Mr. Brown, you represented in this case by your attorney James Paget. Attorney Paget, how are you doing?
Good morning, Your Honor. I'm doing well.
That's good. Mr. Paget, what is your announcement in Mr. Brown's case?
We'll need this placed on your plea docket, Your Honor.
Okay, give us a
Just
reset.
your regular reset will be fine.
Okay, yeah. What's this? November the what? 7th. Okay, so this case is reset for November 7th of 2022. Ms. Brown, Mr. Brown, your case is reset for November 7th of 2022 at 9 a.m. Your bondsman and your attorney will be given notice of your reset. Stay in contact with your attorney and your bondsman. If it's set for a plea, you need to be here in person. Mr. Paget, your reset will be sent to you.
Yes, Your Honor.
And Mr. Brown, you're free to go and you have a blessed day. Mr. Paget, I think this is your only case.
Yes,
You're free to
Your
go
Honor.
as well, and you have a blessed day.
Thank you, sir. You too.
All right, thank you. Court is back in session at cause number 322623 and cause number 324253. Both cases, style of state of Texas versus Gustavo Gomez Vasquez. Mr. Vasquez, is that your full name? Mr. Vasquez, would you please raise your right hand? Mr. Vasquez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Vasquez, you may put your hand down. Now, Mr. Vasquez, I have before me two documents. The first document that I have is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line stating that you want to apply for court-appointed counsel? Mr. Vasquez, I also have another document here. This document is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of this same document, there's an initial above the line that's titled Defendant Signature. Is that your signature?
Yes, sir.
Now, Mr. Vasquez, before you signed and initialed all of these documents that I've just mentioned to you, did you read the documents? And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, so Mr. Vasquez, I've read your answers in these documents, and based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case, Mr. Vasquez, is Attorney Bruce Cobb. Attorney Cobb will be given information on how to contact you, and you will be given information on how to contact Mr. Cobb from our court coordinator. Once you get that information, you'll be free to go, and you have a blessed day.
Thank you, sir.
Okay, so Mr. Vasquez, you're gonna stand on the X in front of our court coordinator so that she can reset your case. You're welcome. Okay, hold on a minute. Okay. Next case is cause number 331098, case of style of state of Texas versus Heaven Lee Andrews. Ms. Andrews, would you please come forward?
I'm present, Your Honor.
Ms. Andrews, is your full name Heaven Lee Andrews? How you doing, Ms. Andrews? I'm doing fine. Thanks for asking. Ms. Andrews, you're represented in your case by your attorney, Attorney Wright Kimbler. Attorney Kimbler, how are you doing?
I'm blessed, Your Honor.
That's good. Now, Mr. Kimbler, what is your announcement in Ms. Andrews' case?
We're ready to proceed, Your Honor.
Okay, so you're gonna set it for this case is a motion revoke probation. Are you setting it for a hearing?
Set for a contested hearing.
Okay, give us a date. No, because no, you just do it on another. We got Ada Christie is here. October 28th? Okay, okay, Mr. Kimler,
Yes, Your Honor.
case will be set for a contested hearing. It's gonna be at 10 o'clock. Okay, it's gonna be set for contested, well, we might be through for 10, yeah. It's gonna be set for contested hearing at 10 a.m. on October 28th of 2022. Your reset will be sent to you, Mr. Kimler. Ms. Christie, you can get your reset here in court. Once you get your reset, you'll be free to go and you have a blessed day. And Mr. Kimler, this is your only case. You're free to go as well and you have a blessed day.
Thank you, Your Honor. You too.
Okay, Ms. Andrews, just have a seat in that chair that has the black and yellow tape. And then when she's ready for you at the window, she'll call you. Okay, next case is our non-disclosure, petition for non-disclosure and cause number 0137539. Case is style the state of Texas versus Deja Brianna Duriso. Okay, okay. Mr. Holloman,
Yes, sir.
you can come forward. And I think, okay, now, Mr. Shearer, I think this is a non-disclosure case. We had a hearing on it before, and I think Mr. Johnson's handled it. And I think the petitioner, when we had the hearing, looking at the petition, there were two issues. First issue was on the date of arrest. They had two dates of arrest in the original petition. I'm looking at the amended petition, still have two dates of arrest. Hold on a minute. And I think he had two dates of arrest. One was February 16th of 2016, and the other date of arrest was July 28th of 2015.
Let me check on this, because I remember there was one where the different discrepancy was because the arrest was in a different county.
Was that it? I know we had another case where there was an arrest in Galveston County. I don't know if it was this one. Yeah. But and I don't know if the person was arrested twice, I guess arrested twice, or let me see.
Arrest date.
She bonded out twice.
Bonded out on the 28th. This is the notes that I have. Yeah, as we called on the 16th of February, and she turned herself in. And she turned herself in and we went to recall. February 16th. But she bonded out on July 28th.
But she had like was she had a fail to appear or something, or? Yeah, you said she was arrested. So she was initially arrested July 28, 2015. Right.
Yes. And that was on the one. When she was arrested, July 28th, 2015.
Okay,
Apparently, she was not arrested at the time of the offense. It was not a instant thing. It was.
well, what was the,
March 26th of 2015.
oh, yeah, okay, I see what you're saying. It was March 26, 2015, when the offense occurred, but she was arrested in July 28th of 2015, that's right? Okay. Okay. Now, the other issue is, I think, and we went over that before. Initially, he had in his original petition, he had that the non-disclosure was under section 411.081. Now, and I think he explained that he got that from the disclosure, yeah, but they changed the statute.
Right, they renumbered the statutes.
Right.
And that's the old.
Right.
numeration.
And then I think that the new statute is retroactive, meaning that,
That is correct.
right, and so those numbers has to comply with the new statute. Now, I see that you put 411.072 and 411.074.
May I please support?
Yes.
That is the first amended.
Oh, you got another amended?
We're on the second one.
Oh, I don't have that one. Oh, could you pull a second amended?
That 072, her order was issued February of 2017. And,
Okay, could you,
and she couldn't get a non-disclosure.
let me see. Oh, that's right. It's a civil case. It's a civil case. Y'all gonna have to look it up. They're gonna, no. We on Duracell. We on the non-disclosure. Okay. Yeah, this is a deferred adjudication probation order. She's placed on probation June 16 of 2016. And then deferred adjudication order of dismissal was signed February 23rd of 2017.
Yes, sir.
Okay. Okay. The state, you have anything?
No, Your Honor, the facts of the case are such that the state would not oppose a non-disclosure.
Yeah, I mean, he got the right provision in here. I mean, he got,
Yeah,
I think it would be, I think it would be the 07, is it the 0725?
That's what I was looking at.
Yeah, because,
7.2,
because I think it's a deferred 073. I mean, you got both of them in here, 073. That only applies to, what up, that conviction. That only applies to straight probation, community supervision, right? Procedure for community supervision following conviction, certain misdemeanors. This applies only to a person placed on community supervision under 42A Code of Criminal Procedure following a conviction. You don't get a conviction on deferred.
Well, what I read said that she was put on deferred probation under supervised.
Yeah, but you have,
And not community supervision.
well, when they
Not
say,
community
it's still, yeah, it's still community supervision.
right,
But the state feels that 0725 would probably be more appropriate.
okay. Okay, you let me see that order. I need to, I think I got it. I need to look at it. Oh, yeah, I need to look at it. Well, I'm gonna take it under advisement and, yeah, because the orders has, yeah, the court has an order that the court, signed, okay. Okay, so, the court is gonna take it under advisement, and make sure that one, the person is entitled to deny disclosure and to comply with the statute, then the court will sign the, appropriate order, okay? All right. Okay, you may be excused. Okay, court isn't,
He's represented by Mr. Brad.
no, that was before he got placed on probation. This is he's on probation. They're asking for the case to be placed on inactive status. Let me do this. This is okay, I guess, yeah. Why don't you come on up? This is cause number, let me see, this one is cause number 327224. Oh, okay. I know. Christian, you can come forward. Okay, this is cause number 327224, case is style of state of Texas versus Tristan Killian. We have Mr. Killian who is present before us. And we also have Mr. Barksdale, who is with the probation department. We have Mr. Ray Shearer, who's with the he's assistant district attorney with the Jefferson County DA district attorney's office. Gentlemen, before we get started, pursuant to Article 1.24, the proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State, which is the case Lilly versus State 365 Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing the disclosure of non-public information, or ensuring that the defendant receives a fair trial. In this case, the court has not only the court's file, but also in the court's file that the court is taking judicial notice of is the psychiatric evaluation that was conducted by Dr. Edward Grapan back in 2021 when Mr. Killian prior to Mr. Killian being originally placed in probation. And so based on that information, there is some non-public information that is in that evaluation. State, do you have any objections to this hearing being closed to the public?
None, Your Honor. I can stay with the court.
Okay. Now, based upon the party seeking the closing of the hearing, the court finds that the party has advanced an overriding interest that is likely to prejudice the defendant in that it will disclose non-public information. The closure is no broader than necessary to protect Mr. Killian's interests, and the trial court have considered reasonable alternatives to the closing of this proceeding, and the court believes that these findings are adequate to support the closing. So at this time, the hearing is closed to the public.